Hey guys, Kate Lincoln-Goldfinch here from Lincoln-Goldfinch Law with your regular weekly live video about immigration updates. As usual, go ahead and say hello, post your comments here, post your questions, share this video with your friends. Any public question that you have, put it in the comments during the video or after the video. If you have something private to discuss, go ahead and give us a call at the number on the screen, 512-599-8500. Or you can send us a Facebook message. You can also do a text message to our main phone number, and we will get back to you ASAP. So today's topic is the two-year green card. We get a lot of questions about people who have the two-year green card and what happens if my marriage is not working out? Am I going to lose my status? And so I want to talk through that with you guys today. And also at the end, I'm going to do an update about the new presidential regulation on student visas, which has a pretty significant impact. I'm hopeful that it's going to get enjoined by the courts, but we've gotten a lot of questions about that. It's going to affect a lot of people on student visas in the U.S. Or out of the U.S., and so we'll talk about that too. Hi, Erin. Thanks for being with us. Hi, Elvia. So good to see you guys here with me today. Great. So the two-year green card. So lots of people who get a green card through marriage are going to get a two-year green card. Anyone who came in as a fiance on a fiance visa and then follows the rule where you have to get married and file for the green card within 2 years is going to get a two-year green card. And then anyone who goes through the adjustment of status inside the United States because like you entered with a visa or you got petitioned before 2001 or maybe your spouse served in the military, then you get to apply for your green card in the United States. That process is called the adjustment of status, and that's the one where you file the I-130 and the I-485 and the work permit and everything in one step. We call that a one step, and you get the work permit while your application's pending and you go to an interview. For anyone who's in Central Texas, you go to your interview in San Antonio and then you get the green card. Hi, Anna. Thanks for being here. Always good to see you. Oh, thank you so much. It's so great to have you here with me every week too. So that's the adjustment of status, and then the consular process is the same essential process where you're married to a U.S. citizen and you're getting your green card because of that marriage, but instead of adjusting status in the U.S., you go through the process where you file the I-130, and then if you've been in the U.S. with unlawful presence, you file the waiver, and then you get ready for your consular appointment and you go to the consulate abroad. So your final step is outside of the country. Everyone prefers the adjustment of status when possible. Not everyone qualifies for it. But those are the three ways you get a green card through marriage. You come in as a fiance and you apply for your green card, you do the adjustment, or you do the consular. So what happens is on the date that your green card is approved, which in an adjustment of status is the date that the officer enters the approval. It's often the same day as the interview, but not always. For the consulate, it's the date that you enter into the country is the date that your green card, your permanent residency starts. If that date if your marriage is less than 2 years old at the date that your permanent residency is approved, then you're going to get a 2-year green card, and it's a permanent residency with conditions, essentially, that you have to prove at the end of 2 years that you're still living with your spouse in a good faith marriage to remove the conditions on your green card. If by the time you apply for your green card or you get approved for your green card, you've been married longer than 2 years, then you get the full 10-year card, and it's unrelated to the marriage. You don't have any other steps except for citizenship when you're ready. And if you separate or get divorced, it doesn't have an impact on your status. But for people who have the 2-year green card, a separation and a divorce can have an impact on your status because remember, you have to remove the conditions at the end of 2 years. So the rule is you have to file the form I-751 within 90 days before the expiration of the 2-year green card. And typically, if you're still together, you file a joint petition. So you both fill out the I-751, you both put your address history, which is the same because you've been together, you both sign it, you attach evidence that you're still living together in good faith, like a lease agreement, joint tax returns, shared bank accounts, any kind of insurance that you might share, all those types of evidence that you submitted when you applied for the green card, but now they're looking for evidence in the 2 years since you've had your green card. Typically, a joint I-751, you submit enough evidence via mail, and you're just approved via the mail. You don't need to go to an interview. Periodically, people get called for an interview, or if you haven't submitted enough evidence, they'll give you a request for more evidence. We often get called in at that point, like if people file their joint I-751 without an attorney and then they get a request for evidence or they get called for an interview, they'll call us and we'll take over and handle it from that point on. Most of the time, we get contacted by people who are worried about their marriage. And they say, I have this 2-year green card and we're fighting a lot. I don't know if we're going to stay together, and I'm really worried about my status and what this is going to mean. The first thing I want to say is do not worry. We do these cases all the time, and I can't think of any case that we've ever lost on an I-751 waiver. So we have a really high success rate on these cases, and we can help get you through it. So basically, if you have separated before the time that you file the I-751, you can't file jointly. You can't show that you're still living together. So you shouldn't ever commit fraud with immigration, and so you don't want to commit fraud on an I-751. So the 4 ways that you can remove the conditions on your green card, meaning you can graduate from a 2-year green card to a 10-year green card if you're not filing jointly with your spouse, are if you have separated, if you're not together and you've been subjected to cruelty in your marriage. And so just like a VAWA case that we talk about a lot on this page, cruelty doesn't mean necessarily that you've been physically abused or that you've filed a police report. You can be subjected to emotional abuse, verbal abuse, financial abuse, sexual abuse. So if you're in a relationship where your spouse is controlling when you get to leave the house and how you spend your money and who you talk to, all of that can be considered cruelty in a marriage. And so like if you're separated, but maybe not divorced yet, we could file a waiver based on cruelty in that scenario. Another way to file it, and these are the 2 most common, is cruelty. And then let's say it was a good faith marriage, but it ended in divorce. So for that to apply, you have to be divorced or have a divorce pending. And so in that case, you don't have to prove cruelty. You just have to say, this was a good faith marriage and now we're divorced. And so then you need as much evidence of good faith marriage as you can get for the 2 years since you've had your green card. And in some cases, you can get your ex-spouse to write a letter and say, like, we tried, we worked on it, it just wasn't, the marriage didn't work out, but it was a good faith marriage. We married for love and it didn't work out. And so that would be a waiver based on divorce. But obviously you have to be in divorce proceedings or be already divorced. One thing to note is that if you file based on cruelty, there's no timeline or deadline. You can file before the 90 days or even after your green card is expired. With divorce, you can't file early. So the third way to get a waiver is if the petitioner has died, the spouse who got you the green card. And then the 4th is hardship. So if the applicant, the person with the 2-year green card, will face hardship if they aren't permitted to remain in the United States, that can be a reason for a waiver. Now, lots of people think, well, gosh, it's going to be hard for me if I don't get to stay here. Like my kids are here, I have my job here. We're not talking about that kind of hardship. Typically, what we're looking for is like almost like an asylum case. These cases are hard to win, and you have to show that you will suffer like severe hardship if you aren't permitted to remain in the United States. So just to repeat, either you get the 2-year green card and you remove it jointly together, you both sign it, you mail it in, or you've separated, or you're thinking about separating, or you're divorced, and then you need one of the 4 waiver categories, which are cruelty in the marriage, good faith marriage that ended in divorce, the petitioner has passed away, or hardship to the applicant. And we've done a lot of these over the years, and we can help get you through it. If this is your situation and you're worried about your marriage, you're worried about your green card, take that worry off the table. I have had so many people in consultations with me over the years just come in just completely frantic about, what about my status? If I leave my husband or my wife, I'm going to lose my green card. And I can say, like, we'll handle it. We will help you get your 10-year green card. Just focus on getting out of your abusive marriage. Focus on whatever you need to focus on and separating from your spouse. and we'll help you handle the other part. Now, it does make sense to talk to us as you're contemplating it, because there's stuff that you should do to protect yourself, like get all of the evidence of good faith marriage before you leave the house. You know, get the lease, get the bank statements, get all the evidence that you might need before you don't have access to it. So things like that we can help you guys think through. But the main message I want to give to you is don't stay in an abusive relationship for your green card. Please, we will help you extend your 2-year green card from a 10-year green card if you're in a situation where you need to get out of your marriage. Let's say you filed the joint I-751, you were together, and now you're separating and your case is still pending. What do? We get a lot of these. Because, you know, honestly, like with a fiance or lots of people who are newly together, maybe, you know, with the fiance process, you got married in 90 days because you were forced to do that, but you weren't really ready. Like, this is the first time you've lived together. You lived in separate countries up until, you know, your fiance came. And anyway, this stuff happens. People separate. So if you file the waiver jointly, the I-751 jointly, and then you've separated, this is my opinion, that it's not your affirmative duty to update. I mean, you do have to update your address with immigration, but you don't have to notify immigration about a change in your marriage until there is a divorce in place. Because lots of people, you know, separate, they get back together, you know, it's not final. But if you get a request for evidence or an interview notice, then you really need to consider switching your I-751 from a joint to a waiver. And we can help you do that. You can call us. We can help you prepare for an interview. We can help you respond to an RFE. You're not alone. This is very common. This happens to a lot of people, and just give us a call. So hopefully I answered your questions about the I-751. If not, go ahead and put a comment or send us a message, a private message. Okay, I want to talk about the student visa regulation. Likely anyone who's watching this who has a student visa or is considering getting a student visa for the upcoming year is panicking about this regulation. So the first thing I want to say is that once again, the Trump administration has issued a regulation without following the proper procedure. There was no notice and comment procedure in place for this regulation. I would guess that there will be more federal litigation on this regulation, and hopefully, possibly, the policy will be enjoined, meaning it'll be blocked before the school year. But essentially what they've said is that students, F1 and M1 students who are coming in, who are going to a school that is 100% online in the fall semester, are not going to be permitted to enter the United States, and if they're already in the United States, they're going to need to depart. If they are going to a school that is all, you know, in-person classes, then you will be permitted to take up to 1 credit hour online, as is the standard. Most people, I mean, Harvard and Princeton are all online. So foreign students who are planning to attend Harvard, who went home for the summer and were coming in, are not going to be able to come into the country. And this is a significant impact for people. But most universities are going to be in some sort of hybrid model. And so the schools are going to need to issue the I-20 saying that this foreign student is not attending classes completely online in order for the student to remain or enter into the United States. So it's going to be up to the International Student Office to notate the I-20 properly for these hybrid models. Now, I think anybody watching this knows how nuts this is. I mean, this is crazy because it's forcing foreign students to make this awful choice to go to class and put themselves in danger during a pandemic, or to make the choice to, like Harvard students, to go to virtual classes and stay out of the country and spend more than $50,000 a year on tuition. That's nuts. And then you think about the universities and the colleges that are going to suffer. They're already suffering with enrollment. It's going to get worse. And then the long-term impacts, both on the lives of student visa holders, but then you think about these universities are going to suffer. And then the course of study, or the trajectory of a student visa is often, the visa holder is often to graduate and to get OPT, work permission, to find a job in the U.S., then to get petitioned by a U.S. employer. I mean, we are cutting off our nose to spite our face with this regulation and really harming our long-term economic benefits from having foreign students in the United States. So it's just nutty. This policy makes absolutely no sense. I really hope that there will be an injunction. We'll, of course, keep updating you guys on this Facebook page. And anytime, just feel free to message us, text us, call us. The number's right here on your screen. We're here for you guys. We're not charging for consultations during the pandemic. We're providing virtual consultations. So there's really no reason not to reach out. And please feel free to share this video with your friends. And I will be back at noon in 30 minutes with the same message in Spanish. So thanks everyone for being with me here today. I see lots of people joining me, and it's nice to see all of your names. And I will see you next Tuesday at 11 for our English video. Take care.